Welcome back to Court TV AP. Today you're about to watch one of the strangest courtroom showdowns we've covered. A defendant claims secret contracts, UCC codes, and even refuses a simple courtroom oath, all while insisting she's ready to defend herself against felony charges. But can courtroom theories survive real law? Stay till the end, because the judge's final decision changes everything.
Your Honor, I had filed a notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're going to be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under Code UCC 1-207. And I have the rights to represent myself and waive all counsel knowingly, willingly, and intelligently. And I would like to.
Right, so you're requesting that you be allowed to represent yourself? Is that what I'm hearing?
Yeah.
824-00390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for competency hearing. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
William Glenn, P. 36794 on behalf of Ms. Tubbs. Ma'am, state your name.
Beneficiary, Tanea Nicole Tubbs.
All right, Ms. Tubbs, you have a constitutional right to be physically present in the courtroom. Do you agree to waive that right and hold this hearing by Zoom?
I agree.
Okay, thank you. Counsel, I've received a report dated February 13th, 2025, authored by Andrew P. Sheff, licensed psychologist, consulting forensic examiner. Have you both had an opportunity to review that document?
Yes,
Yes, yes, Your Honor.
Do you both stipulate to that being admitted as court's exhibit number 1?
Yes, Your Honor.
And that'll be marked and admitted as court's exhibit number 1. All right, and do you stipulate to its findings?
Yes, Your Honor.
Yes, Your Honor.
All right, then the court will find that it says opinion. It's my opinion that Ms. Tubbs is competent to stand trial.
Yes, Your Honor.
Okay, then it says, the last paragraph says, while I recognize the ultimate decision in this matter rests upon a judicial determination, it's my opinion that Ms. Tubbs was competent to stand trial at the time of this evaluation. You both stipulate to both of those findings?
Yes, Your Honor.
Yes, Your Honor.
Next, then the court will sign an order. Is she receiving medication?
She's in the Calhoun County Jail. I don't know yet.
Ms. Tubbs, are you receiving medication?
No, Your Honor.
No medication? All right.
No, ma'am.
And counsel, are either you aware that she's receiving medication?
I am not aware, Your Honor.
I am not aware, Your Honor.
I don't see any mention of medication here, so. All right. And I'm signing the order finding her competent to stand trial. And do we have a trial date on this matter?
March 17th.
What date?
March 17th.
Okay. So this matter is scheduled for March 17th at 9 o'clock. Has counsel had a chance to discuss whether this matter is going to be resolved or not?
Your Honor, I had filed a notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're going to be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under Code UCC 1-207. And I have the rights to represent myself and waive all counsel.
Here's an important legal distinction many people confuse. Being found competent to stand trial doesn't mean the court believes you're innocent or guilty. It simply means the judge believes you understand the proceedings and can participate in your own defense.
Knowingly, willingly, and intelligently. And I would like to.
All right, so you're requesting that you be allowed to represent yourself? Is that what I'm hearing?
That's correct.
All right. Well, then I'm going to voir dire you with regard to that decision. Would you like an opportunity to speak with your client in the breakout room with regard to this decision, counsel?
Well, she said that a couple of times, but I would ask that the court hold off on that until I get the criminal responsibility. So, once I get that, then if she wants to represent herself, then we can,
Well, ma'am, do you want to do are you saying you're not going to do the criminal responsibility evaluation?
I do not need to do any of that, sir.
I'm sorry,
that's defamation of character. I will not be doing any of that. And I would like to exercise.
You are requesting that you not do a criminal responsibility evaluation. Is that my understanding, ma'am?
That is your understanding. Correct.
Well, yeah, with the MIDC's policy, I don't know if I can continue as her attorney of record. She has to have standby counsel appointed if she's going to represent herself. That's my understanding of their current policy.
All right, and you do standby counsel?
No, yeah.
All right, well, would you like to talk with her before she makes this decision? I'd like to have you speak with her.
Yes, Sean.
So, ma'am, I'm going to have the attorney go into a breakout room with you and just talk to you. This is a very important decision. I'm not saying I'm not going to do it, but I just want you to talk with him and understand some of the risks of doing this. And okay?
Your Honor, I understand all the risks, and I do not wish to talk to him. I have not talked to him in 6 months, so why would I need to talk to him now? Thank you. I pray you respect my wishes.
So just so I'm clear, you're refusing to talk with him. Is that correct?
Correct. I understand all the consequences and repercussions in this case.
Okay. All right. Then let's, ma'am, we're going to need to have you sworn in for you to self-represent yourself, okay? I want to ask you some questions just so you understand. Can you swear her in, please?
Ms. Tubbs, please raise your right hand in front of the camera where we can see it.
I do not swear in, but I wish to tell the truth and nothing but the truth.
All right. Then will you affirm?
I'm here to reserve my right.
Let's have you raise your hand and you can affirm, okay?
Do you solemnly swear to
do you solemnly affirm?
Do you solemnly affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth.
Okay, you have to put your right hand up, ma'am, please. Let's do it again.
That's against my religion, sir.
All right, then, ma'am, I'm not going to have you self-represent you until you do this. So if you're not going to do it, we're going to continue the attorney with you. All right? So you tell me what you want to do, Ms. Stubbs. Because until I go through these questions with you under oath, we're not signing any. We're not.
But I need to know what oath am I going under, sir? I have the right to know what oath I'm going under because I don't go just under any oath.
All right. Well, let's have her raise her hand again, and you say the affirmation. It's not an oath. It's an affirmation. Raise your right hand, please, ma'am.
Do you affirm?
No. Yeah. Okay.
Do you affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth, and I come in as beneficiary, affirm.
All right, thank you, ma'am. What's your name?
I am the beneficiary, Tanea Nicole Tubbs.
All right. Do you understand that you have a right to have a lawyer represent you in this case?
Yes, sir.
Do you understand that I will appoint a lawyer to represent you if you cannot afford a lawyer?
I waive that right.
Huh?
I understand what you're saying, but I waive that right.
Okay. Do you want to have a lawyer represent you?
No, sir.
Can you afford a lawyer?
Yes, sir.
Okay. What is the maximum sentence in this matter, Madam Prosecutor?
In this matter, Your Honor, it is
Punishable up to 5 years or
It's-
fine not.
Ma'am, just wait. Let me speak, okay?
I'm sorry.
it would be 7.5 years because the defendant, it's carrying concealed weapon, which is a 5-year maximum penalty, but there's a habitual second offense notice, so that would increase the penalty to 1.5 times the maximum sentence, which would put it at 7.5 years.
All right, ma'am, the maximum possible sentence in this matter is 7.5 years because you are a habitual offender second offense notice. So it's 7.5 years is the maximum sentence. Would you like to talk with a lawyer, with a court-appointed lawyer to decide if you want to represent yourself or not?
No, I would like to represent myself and put in the motion to dismiss.
Okay. So, ma'am, first of all, can you give me your educational background?
I have
How far have you gone in school, ma'am?
college.
College, okay. And have you represented yourself before?
Yes.
And why do you wish to how many times have you represented yourself?
Twice.
Okay, and then what were those in criminal matters?
One is, yeah.
And what happened with that case?
I got it dismissed.
Okay. And what was the other case you represented yourself, Ms. Tubbs?
I'm actually doing that now. It's for another criminal case, actually.
And you're representing yourself in that case?
Yes.
And why do you wish to represent yourself in this case?
I wish to represent myself in this case because I have learned all the trade secret acts, and I'm fairly fed up with how this courtroom is operating and suing people without letting them know that they are entering into a contract with you all as owning our vessels, and I'm tired of it. I'm tired of it. No one owns me.
All right, ma'am, tell me what the elements of this offense are.
The elements of this offense is that it's punishable by imprisonment for more than
No, that's
5.
not what the elements of the offense are.
The elements? What do you mean by elements? Because you know y'all.
Well, that's the problem. You don't know.
Here, so I know.
How are you going to represent yourself if you don't even know the elements of the offense? How are you going to do that, ma'am, if you don't even know what you have to defend against?
I have to defend against the accusations, the charges.
All right, ma'am, tell me what the rules of, do you know the rules of procedure?
The rules and procedures to this is that, yes, that a prosecutor, the people of the state of Michigan is trying to sue my corporation. That's correct, right? And you are acting as a trustee, correct? Y'all acting as judges and acting as trustees, correct?
No, I'm elected as a judge. I'm not a trustee. I'm a judge. Okay, ma'am.
Okay, so what?
Ma'am,
so
no,
what?
You don't get to quiz me, Ma'am. What do you know? What the rules of evidence are?
Yes.
Okay, tell me what the exceptions to the hearsay rule are.
Acceptance of the hearsay. Hold on, I want to write all this down.
I'm sorry. No, I'm asking you. You say you know this stuff. How are you going to represent yourself?
You got acceptance of hearsay, sir. I would like to write everything you're saying down so I can
Have
be
you
able
ever
to.
have you ever done jury selections or jury instructions?
Yes, jury, it holds up to 12 people.
No. Do you know how to ask them questions?
Yes.
And how to do the jury instructions? All right. Do you know how to preserve issues for appeal?
Yes.
Do you know that self-representation is almost always unwise?
Yes.
Did you know that the first day of law school, they tell us that he who represents himself has a fool for a client? Do you know they tell us that?
Yes.
And so what does that tell you if they say he who represents himself has a fool for a client? What's that tell you, ma'am?
This is where the courtroom starts hitting the brakes. Before allowing someone to represent themselves, the judge has to make sure every legal requirement is satisfied. Refusing even a basic affirmation can stop that entire process before it ever begins.
So where are we at on this matter?
So what we discussed was Ms. Tubbs stated that she didn't have all the discovery, so the prosecutor went and printed all of the discovery. In terms of digital discovery, since Ms. Tubbs will still be in the Wayne County Jail until the trial, I'll put it on a flash drive and take it to the jail.
Okay.
She just would need a laptop.
All right, you want me to order a laptop for her?
Yes.
All right, then I'll order that Ms. Tubbs is to receive a laptop from the jail. All right, any other matters we need to take up?
The only thing I would like to indicate for the record, Judge, is that I am right now the only thing that I didn't include in the discovery. It was, I realized as I got down here that I didn't print the witness list, so I'm going to send that to the court and ask if Marita would be so kind to print just a copy of the witness list off. I will say that as far as paper discovery goes, I have included the felony information with all of the charges, the investigator's report, which is 3 pages, the reports from the police officers, which are 13 pages, the defendant's statement, which is a 3-page document, the Center for Forensic Psychiatry report that pertains to our case because we did not get any of the other ones from Calhoun County. The notice of insanity defense that the prior attorney, Attorney Glenn, had filed. And with regard to the preliminary exam, I did check. It was waived, bound over, so there is no
requested that be terminated, correct? That request for insanity defense? Do you don't want it do you want an insanity defense?
No.
Okay.
I just wanted to make sure that I provided a copy of it.
I make sure we have an order that she has requested the withdrawal of an insanity defense. I think we already did that, but if we didn't, we need to sign that today.
Okay, and right now, your court clerk did print off the witness list for me. So I'm adding that on the discovery, and it is 1 page, Your Honor. And then I've put all of the discovery together, the paper discovery together, in a white envelope that the defendant will be able to take back with her and have a physical copy for herself.
All right, can we give all of that to her right now?
Yes, I am.
Oh, I have a request.
Ms. Tubbs would like to address the court.
All right, Ms. Tubbs, you're receiving all that documentation, correct, ma'am?
And these are the
Wait, no,
Yes.
we're gonna do this
Yes,
one
I'm
at a time.
receiving the
Ms.
discovery
Tubbs,
package.
have you received all the discovery she just said?
Everything but what she said, the witness list.
All right, it's my understanding you gave her the witness list too, correct, counsel?
Yes, I added the witness list.
Also the injured party.
It's in the discovery.
Okay.
You just gotta read
All right, so you have the witness list. Do you agree to that, ma'am?
Yes.
And you have all the other discovery, correct?
As what she gave me, yes.
Okay, what else? What else, ma'am?
the digital, but I'm gonna provide that.
You're gonna provide that, okay, all right. Anything else?
Besides, I would like to approach the bench.
Well, you can speak from there.
I can speak from here.
Yeah, okay.
All right, thank you.
Yeah.
I'm asking for this court to dismiss this case on behalf of the facts that this is a Nisi Prius courtroom. This also goes by equity, which also has no jurisdiction over me. I am not an entity, nor am I subject to an entity. And I have given all my rights that been infringed, which this goes by the Constitution, correct? And this goes by equity, correct? So by that being said, my rights was infringed. I have the right to bear arms, and I have the right to travel. And that's
Anything
why.
else? Yeah, your motion to dismiss, Stacy. Anything else?
That's my motion to dismiss. You
Okay.
also gave.
Is there anything else with your motion to dismiss? I need to rule on that once you're done.
Yes.
Anything else on the motion to dismiss?
Yes.
Okay, go ahead, man.
My due process has been violated. Right
Okay.
to life and liberty. The 180-day rule has been violated. There is no crime. If there is no injured party, I'm the only injured party. And that will be all. Besides, I reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of the compelled benefit under any unrevealed contract of the commercial agreement.
Okay. Anything else with regard to your motion to dismiss?
I'm just asking for a motion to dismiss.
Okay. There is absolutely no basis in law with regard to your motion to dismiss. I deny it. Anything else we need to take up, man?
So the only other thing was the documents that we were speaking of when we were on Zoom. Ms. Tubbs did obtain those, and she just wants me to give them to the prosecutor.
Okay. I have no idea what documents you're talking about, but
It's the bill of complaint and equity, presentment to void proceedings and jurisdiction.
And also my affidavit of truth.
And yes.
It's on the other day. In my Cessna Q trust, because this is accordingly to.
I'm gonna need you to speak up, ma'am. It's a big room.
Also, it's for my Cessna Q trust. I am the beneficiary over the trust account. You guys are acting as a.
That really has nothing to do with this courtroom. But
really
anything else, ma'am?
It does.
Anything else?
But you can say that. No.
Right? Have you discussed potential resolution of this, Madam Prosecutor?
Your Honor, I have not talked to the Ms. Tubbs today, and the last I heard prior to her going off the record is that all she wants is the case dismissed. I don't know that there is a resolution that Ms. Tubbs would be amenable to. And the last time I spoke with her, when we were on Zoom, she indicated that the only thing she is seeking is a dismissal, which the people are.
Well, I denied that dismissal. We're scheduled for trial on March 17th. I don't accept pleas on the day of trial. Do you want to discuss resolving this matter with the prosecutor, or do you just want to come here March 17th at 9 o'clock for a jury trial?
I would like to discuss some resolutions.
All right.
The only thing that I can think of, Judge, in talking to your deputies is if the court wanted to turn.
We're going to do this in here.
Okay, that's what I was going to say.
I'm going to ask everybody to step out of the courtroom other than Ms. Tubbs, her attorney, and you.
Okay.
And I'm going to turn off Zoom and that type of thing, and then let you discuss that. But I'm going to ask everybody to please step out of the courtroom, and we'll reconvene once they're done discussing everything.
Case 2400390201. The people of the state of Michigan versus Janaea Nicole Tubbs. This matter is scheduled today for a pretrial. Appearances for the record.
Good afternoon, Your Honor. Elena Rozak on behalf of the people, P78815.
Good afternoon, Judge Dion Patillo, P82378, standby counsel for Ms. Janaea Tubbs.
Great afternoon. Coming in as the principal and beneficial equitable title holder, Janaea Nicole Tubbs, beneficiary, natural living being. Coming in UCC 1-207, UCC 1-308.
Counsel, where are we at on these matters?
Your Honor, I believe that this is going to go to trial on March 17th. We did have an opportunity once the court excused itself and gave the courtroom to us to review some of the digital discovery with the defendant. Not all of it. There is 5 different videos, 3 police officer body worn cameras, 2 scout car videos. One of them is of the front of the scout car looking out. The other one would be for the back seat of the scout car. We have not gone through every single one of them, but we went through 2 different angles of body cams and that covered the incident that the defendant is charged for. She and I have a disagreement on what the actions were and what the facts are, and therefore that's what a jury trial is for.
Okay. Can you put on the record what the offer is, what the sentencing guidelines call for, and what you're going to recommend as far as a sentence, just so Ms. Tubbs understands everything?
Let me just double check really fast.
Okay.
It's long.
She said she's got it. On Zoom.
Oh, nice.
Okay, Your Honor, with the guidelines, the guidelines as charged, if the defendant were convicted of 1 count of carrying concealed weapon, 1 and 2 counts of resisting and obstructing a police officer, and the habitual second offense notice, the guidelines would be 7 to 28 months to a maximum of 7.5 years.
Is she habitual?
Yes, a habitual second offense.
Okay, what's your offer?
The offer in this case, Your Honor, this is what I explained to the defendant also, is that there was a no reduced plea on this initially, and that the supervisors were asking for a mitigation package. Given the history of this case, there was no mitigation package that was submitted. The only thing that I could do at this point would be to ask the supervisors to consider something without the mitigation package and explain the history of the case and whatnot on my own. But I don't, in my conversations with the defendant, I don't know that is, I don't know where that would get us.
Okay. And what are you going to be recommending if she were found guilty at the time of trial?
Your Honor, it depends, but I would say somewhere in the realm of 2 years in the Michigan Department of Corrections, up to with a tail of 7.5 years with the habitual.
And ma'am, the court is no longer bound by sentencing guidelines. I could give you a sentence less than the sentencing guidelines. I could give you a sentence within the sentencing guidelines, or I could give even more than 28 months, which is 2 years and 4 months. Understanding that, would you like to talk with your attorney about seeing if you can get some type of an offer that you'd be agreeable to, or do you want to go ahead and do a jury trial?
I tried to find out what the offer was. She said she didn't have one.
All right. What kind of offer are you looking for, man?
I really want a dismissal, but the
Okay,
only
not
offer
getting
that,
a dismissal, we're beyond that, so.
okay, I get that.
Okay,
Well, the only offer I can see is because I'm not a habitual. I've never been in trouble with
she said you're a habitual second.
I never had a gun charge. I've never
Well, I
had.
don't know about a gun, but a felony conviction?
I'm,
It's, December
Somebody- she's
13th.
a Habitual second, what is it?
December 13th, 2013, fleeing and eluding in the 3rd degree in Calhoun County. It says that you were convicted.
how does Calhoun County have anything to do with Wayne County?
State of
It's
Michigan.
the state of Michigan. Okay, well, that charge was dropped, correct?
Well, it sounds like you were found guilty of something. You must either pled or had a jury
I
trial.
was dropped. That charge got dropped. From my recollections, that charge was dropped.
Well, they're saying that it's not.
Okay.
So anyway, tell me what if anything, you want the prosecutor to go and see about getting. What type of an offer would you be willing to take, man?
If anything, probation.
Okay. All right, let me talk.
No
to
jail
both of you.
time.
I'm sorry?
No jail time and probation. I'm sorry.
All right, let me talk to both the attorneys.
I do have
okay?
8 children.
I'm sorry, what?
I'm sorry. I do have 8 children. And I've been away from them already 7 months.
All right, so let me talk to both of you.
What started as a routine competency hearing quickly turned into a masterclass on why courtroom theories don't replace real legal procedure. The judge respected the defendant's constitutional rights, but only after making sure she understood exactly what she was walking into. The biggest lesson: having the right to represent yourself doesn't mean it's the smartest decision. Let us know in the comments, did the judge handle this perfectly, or would you have done something differently? If you enjoy real courtroom breakdowns with legal analysis, subscribe to Court TV AP, and we'll see you in the next case.